What damages can I get from a court in an unlawful detainer money judgment? Hi, my name is Rob Wells. I'm the Landlord Warrior on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos. Now, I just got out of court defending a landlord's eviction judgment. The war story was we did a stipulated agreement for a certain sum of money. Tenant agreed to pay that money within so many days, didn't do that. So this tenant tried to challenge entry of judgment after we applied for a judgment. So for people that have done an eviction, if you do a court settlement agreement, usually what we do is put in terms that, hey, if you breach the agreement, you get a money judgment. Well, this lady, I guess for whatever it was worth, was trying to stop a sheriff's lockout from happening and stated that she didn't owe the money because she paid on time. Long story short, she didn't even show up to court. Judge was like, well, she's not here. It looks like there's a violation of the agreement. So yeah, you guys got the judgment according to plan. So the next step was landlord was asking, hey, can I add, like damages to the unit that the tenant caused? Because, after the sheriff's lockout, and after any sheriff's lockout for that matter, it's been like my experience that the place is tore up, okay? And there's trash, and it's just like place has been destroyed. A lot of landlords are kind of shocked about that. But when you see it day to day, that's kind of the MO with those types of deals. So this landlord was asking me, can we add those damages? Can we add, any future rent and so forth? And the answer is no. The reason why the answer is no is the eviction statute that governs what a court can award in an unlawful detainer is fairly limited. I believe it's Code of Civil Procedure 1174 that governs what can be given. So, like for example, in rent cases, the court can award the unpaid rent on a 3-day notice, plus any what we'd call in legalese daily rental damages or holdover damages. It's basically a holdover damage is any the daily rent divided by 30 days, basically from each day that the tenant unlawfully detains the property or is in possession. So normally when you issue a 3-day notice, the tenant has 3 days to pay their rent or do whatever. The 4th day and so forth, if they don't move out or they don't comply with the notice, they're unlawfully detaining the property. So that's kind of where we get those damages from. Those damages can be awarded from the day the notice expired, or in cases for rent, the day after, the rental period covered in the notice up until entry of judgment. Courts are also authorized to award court fees, some statutory costs like your process serving fees, and if your a lease agreement allows for it, attorney's fees. That's pretty much it, okay? Judge can't award any damages done to the unit or so forth. What do you have to do in those cases? You have to go file a separate case. Usually a small claims case is the most efficient and most cost economical way of dealing with these things. Or you could go file a superior court lawsuit if the amounts are over the limits of the small claims court. So that's what I have to tell owners, that they're kind of like, oh, okay, I get it now, but that sucks, And I tell them the whole point of it is, and the courts have said it before, is evictions are expedited proceedings, so they don't want to tie up the gears of the legal system with a bunch of other claims. So that's why the statute's written that way. So you got a problem like this, or you got a landlord-tenant issue, feel free to reach out. We'll try to help you out. Put your comments down below or your questions below. I'll try to answer them to the best of my ability. Till next time, folks, I'll see you then. Thanks.